Distinguishing, overruling, and reversing. Distinguishing. This is a technique that a judge can use to stop implementing a previous decision that he would otherwise have to obey. This ensures the judge finds that the underlying facts of the case he determines are sufficiently different to differentiate between the present case and the previous case. He is then not constrained by the situation before him. Balfour v. Balfour, 1919, and Merritt v. Merritt, 1971, are two cases that illustrate this method. A lady filed a lawsuit against her spouse for breach of contract in both situations. It was determined in Balfour that the lawsuit could not prevail because there was no attempt to develop civil relationships, there was only a marital partnership between a husband and wife, so there was no legally binding contract. The second case was successful because the court found the circumstances of the two situations to be sufficiently different in that, although the plaintiffs were husband and wife, the agreement was reached after they had divorced. Besides, the agreement was made in writing. It separated the situation from Balfour. The Merritt deal was not only a territorial agreement but also a legally enforceable contract. Balfour and Merritt are cases that are applied at many places. Remember them. Overruling. This is where in a later case, a judge claims that in an earlier case, it is incorrect to determine the legal rule. Overruling may arise when a higher court overrules a decision taken by a lower court in an earlier case, such as the Supreme Court overruling the Court of Appeal's decision. It can also arise when the European Court of Justice overrules a ruling it has made in the past, or when the House of Lords has used its authority under the Code of Procedure to overrule its own judgment in the past. An indication of this was seen in Pepper v. Hart, 1993, when the House of Lords decided that it was possible to use Hansard, the archive of what is said in Parliament, while trying to decide what certain terms in Parliament's Act represented. This ruling overruled Davis v. Johnson's earlier decision, 1979, when the House of Lords decided that it could not review Hansard. Reversing. This is where a higher court in the system in the same situation overturns a lower court's decision on appeal. The Court of Appeal, for instance, may interfere with the High Court's legal ruling and come to a different view of the law. It overturns the High Court's decision in this case. Judicial lawmaking. While there used to be a line of thought whereby judges did not, in fact, construct new law, but simply declared what the rule had always been, it is well known today that judges utilize precedent to create new laws and expand old concepts. There are several aspects of the law that trace their origins to the judge's decisions. Law of contract. Basically, all of the main rules regulating contract creation derive from case-specific cases. In the 19th century, many of the decisions were made, but today they also influence the rule. Tort of negligence. The major area that has been established and perfected through judicial decisions is the rule of responsibility in tort law. A significant starting point in this area of law was the case of Donahue v. Stevenson, 1932, where the House of Lords established what is regarded as the neighbor check when it recognizes that a producer owes a duty of care to the absolute customer. In his decision on the issue, Lord Atkins said, "You will take reasonable care to avoid actions or omissions that are likely to injure your neighbor you may fairly predict." This definition has been used in several different situations by courts, so the abuse of incompetence has become huge torture. An important expansion was in the case of Ogwo v. Taylor, 1987, where it was established that a man who negligently started a fire in his roof trying to burn paint with a blowtorch owes a duty of care to a fireman who was burned trying to put out the fire. Major developments have also arisen in case of law regarding responsibility for emotional shock where damage has happened. In the case of South Yorkshire's Alcock v. Chief Constable, 1991, which included claims made by people who had lost families in the Hillsborough incident, the House of Lords established the rules for this area of law. Criminal law. The judges played a major role in the creation of the rule on motive in criminal law. E.g., the intention to kill includes not only the intention to kill but also the attempt to inflict grievous bodily harm only because of judicial decisions. Judicial decisions had also created new offenses successfully, as in Shaw v. DPP, 1962, which produced the felony of fraud to corrupt public morality, and Art v.R., 1991, when it was determined that adultery in marriage could be an offense. There have been cases, however, in which the House of Lords refused to change the law, saying that only Parliament should make such a change. It occurred in CVDPP, 1995, when it failed to remove the assumption that the children aged 10 to 14 were unable to have the requisite intention of committing a crime. This rule implied that there must always be proof that the kid realized he or she was doing something that was seriously wrong. In addition, in the Crime and Disorder Act 1998, the legislation changed the law further. Should judges make law? This part is very important for analyses. Do not miss out on the pros and cons. It is claimed that making law is inappropriate for judges. Their job is to put the rule into practice. It is Parliament's responsibility to make the rule. Parliament has selected to do this, but it is not the jury. This suggests that it is undemocratic to make laws by judges. But in fact, in some cases, judges have to make law. The first is where a case involves an outstanding legal point. Since there is no law on it, a decision must be made by the judge in the case. The stakeholders in the lawsuit would not, after all, want the judge to hesitate to handle the case, they want the question to be resolved. The second aspect is a little more complex. This is where judges overrule old cases to create new rules in this manner. In this way, it is necessary to amend the legislation. The 21st century legislation must be focused on the culture and beliefs of today. Law passed 100 years ago, or more, may no longer be appropriate. Ideally, Parliament will amend the legislation, but there are periods that Parliament is unable to do so. When courts have never overruled old cases, the statute may be outdated. The case of R.V.R. 1991 is an example of this. A man has been charged with raping his wife in this situation. The argument the court had to determine was whether a wife consented to sex with her spouse simply by being married and could never say no. The old law dated back to 1736, where it was said that the wife gave herself up to her spouse through their mutual consent to marriage, which she could not revoke. In other terms, a woman was always believed to agree while married and was unable to object to this. In R. v. Miller, 1954, this was still considered to be the rule, even though the plaintiff had already begun divorce proceedings. This law had not been amended by the Parliament. Therefore, when the R. v. R. case was brought before the judiciary, the judges had to determine whether to follow the old rule, or whether to change the law to suit the late 20th century concepts. The judges in the House of Lords found out that women's position and married woman's role in our legislation has shifted quite drastically. A husband and wife are also joint partners in marriage for all practical purposes. As a result, if a woman does not agree to sex, her spouse would be accused of rape. The House of Lords claimed that the common law is worthy of adapting in the face of increasing social, economic, and cultural developments. This clearly recognized that, if they thought it necessary, judges in the House of Lords could change the law. The same power now applies to the Supreme Court. The effect of an Act of Parliament. In the UK, the Parliament is sovereign and no one should dare messing with it. Remember, Parliament anything. Although judges can and do make law, the decision is subject to statutory law, discretionary laws, and EU regulations. This means that if, for example, a Parliament Act is passed and that Act contains a provision that contradicts a case that has been decided before, that case decision will cease to have effect. Parliament's Act is now the law on that point. This happened in 1996 when Parliament passed the Law Reform Act, Year and a Day Rule. Court rulings up to that point indicated that a person could only be charged with murder or suicide if the victim died within 1 year and 1 day of sustaining his injuries. The law enacted that there was no time limit, and even if the victim died many years later, an individual could be convicted, and lawsuits follow the law since 1996 and not the old court decisions. Comparison with other legal systems. Codes of law. Many jurisdictions have a method of reviewing prior court rulings, but they are not as strict as the England and Wales legal precedent framework. Precedent plays a much less important part in countries that have a code of law. This legal system operates in many European countries. The judges are less likely to make legislation. The code should provide for certain cases, and therefore the role of the judge is to read the code. Since the code is the basis of the statute, it is not so closely followed by judicial decisions. Even lower court judges can refuse to follow another court's decision if they believe the code has not been properly interpreted. Less rigid precedent. Analysis. Talk about what courts are rigid, pros and cons of the rigidness. Even in other nations with a common law system close to that of Britain, where case rulings are a significant part of the law, the precedent theory is not so narrowly applicable. For instance, in the United States of America, if it does not comply with scholarly support, a prior ruling is likely to be ignored. If there is significant disapproval of the judgment from leading academic attorneys, judges are likely to take notice of that opposition and rule accordingly in later cases. In the case of R. v. Shapuri, 1986, this has occurred throughout Britain, but this is a rare occurrence, while it happens more often in America. In America as well, situations in which the court's counsel differed, so that the ruling could have been taken by 3 or 2 jurors, are likely to be overruled in the future. In England, it doesn't make the rule less important because the majority was less. Prospective overruling. The other distinction is that the prospective overruling method is used in Europe. In the situation being resolved by the judge, that means that the rule is not modified, but it is updated for the future. The courts are unable to do this in England. Once a ruling changes the law, it will shift in the actual case. This was defined as Dogg's rule, that is, you don't realize that you've done wrong until the court changes the law in your situation, just as a dog doesn't think it's done wrong before you discipline it. This is what took place when it was decided in the case of R. v. R. 1991, that rape within marriage could be a crime. Prior decisions had held that this was not a crime until that case. In a case, this can be considered unfair to the parties. In such situations, it is better to use prospective American overruling.